we have a republic, which is a representative democracy. We elect people to represent us in Washington. Interestingly, what has happened over time is that the framers were really, really afraid of pure democracy. They saw that past examples of that in history, like in ancient Greece, had not gone well. And so they wanted the people to have sovereignty. But by doing it, they thought they had this system of filtration. That when you go vote, you usually vote for people very, very much like you, only a little bit better. And so they thought that in voting, that you would kind of filter out and elect the best and the brightest. And the more filters you had in the system, at the very, very top, for like the U.S. Supreme Court or President or the U.S. Senate, if you have lots of filters to get to those individuals, you have really the best and the brightest. Well, what's happened over time in American history, through especially the Jacksonian era and then the progressive era in the 1910 to 1920, is you had a number of those filters being taken off. So these days, you don't have to be a wealthy, property, white male to vote. You don't have the state legislatures electing the U.S. Senate. The people really choose a president and not the Electoral College unless the election's really, really, really close. But you're not going to elect someone who is not elected by a large number of the people. So a lot of the filters have been taken off, but still, despite that, what you really have is you have a representative democracy, and not a pure democracy. Some people would like to take further filters off, so there's referendum and initiative and recall that you have in some states, especially Western states, that give more power to the people, but more conservative states, Eastern and Southern states generally do not have those, but newer states and Western states do have those. That would be one way to take more filters off and allow the people to really decide on legislation or things like that. But it's a representative democracy. Okay, so the first article is with the legislature. It is divided between the House and Senate. The House, one thing that might not be known, a House of Representatives is 435 people. Does it have to be 435 people? The answer is no. It doesn't say in the Constitution it has to be 435 people. And in fact, at the very beginning, it was 69. But it just said that every 10 years you're going to count the representatives, will then divide up the representation based upon population, based upon how many, what the population of each state is, and that therefore will apportion to each state a number of representatives. But it doesn't say how big the overall House will be. And it is up to Congress itself to decide how big the House will be. And up until 1911, every 10 years they had a different number. Usually it gained in population. In the 1840s, it actually decreased by 10. Until after the 1910 census, they had it at 435. And they just decided that that was a good number. In 1920, there's this huge dispute, and they just kept it at 435. And then in 1929, they said, well, this is a good number. Let's just keep it at that. But if they wanted to, they could make it much larger, or even smaller if they wanted to. So there's nothing magical about 435, but it's just the way that things have gone. Also, there's nothing constitutionally that you have to have single-member districts. So these days, Georgia has 14 members of the House of Representatives. You have 14 single-member districts, and so the 14th district in the Northwest is electing someone to replace Marjorie Taylor Greene right now. Carrollton's in the 3rd district, but you have 14 single-member districts that have approximately 750,000 people apiece. But there's nothing in the Constitution requiring single-member districts. That is up to Congress, because Article 1, Section 4 says that the states can decide the times, places, and manners of electing people to Congress unless Congress wants to intervene. In 1842, Congress intervened and said, we're going to use single-member districts. About a third of the states use something other than single-member districts, including at-large general ticket voting. Everyone in the state voted for all the representatives, or multi-member districts, or a combination of multi-member districts and single-member districts, until 1842, when Congress said, we're going to use single-member districts. 1872, Congress also used Article 1, Section 4 to set a specific election day. That, even numbered years, the Tuesday after the first Monday in November, you elect all members of Congress. And that's why we go and we have election day and elect members of Congress, because Congress has said so under Article 1, Section 4. Before then, states had elections on all different sorts of days. Virginia was in August. North Carolina was in July. Other states were in April. One thing that I've always, if Congress was really, really concerned with gerrymandering, they could, under Article 1, Section 4, set a rule for the designing of districts for every state in the Union. And say that, have some sort of rule about, partisan representation if they wanted to, or not partisan representation, designing it, based upon, computer models or things like that. If they really, really, truly wanted to get rid of gerrymandering, they could simply by passing a law. Now, of course, will they ever do that? No. Why? Because members of Congress are in Congress because they have been elected from districts that elect them, that have been drawn to elect members of their own parties, and so it goes against their political interests to want to have a fairer districting scheme. What else can I say about Article 1? Someone wanted to know about the Congress's role in the military. That is through Article 1, Section 8. The powers of Congress are listed in Article 1, Section 8. Things like, taxes, the commerce power, regulating interstate and international commerce, post offices, post roads, laws on naturalization, patents, copyrights, the District of Columbia, lower federal courts, are all in Article 1, Section 8. But it also says Congress has the power to declare war. Congress has the power, it has the role to have appropriations to support the Army and Navy for up to 2 years at a time. Rules for the militia, calling the militia into actual service, and rules for the land and naval forces. All of that is in Article 1, Section 8. The President then, in Article 2, is named the Commander-in-Chief. Now, one thing that is interesting is that even though Congress declares war, do you know how many times Congress has officially declared war? 5. War of 1812, Mexican-American War, Spanish-American War, World War I, and World War II. So the last 125 years, they've only declared war twice. Yet every president since McKinley has sent American servicemen abroad. So it's interesting. So if Congress wanted to, they could, for instance, refuse to fund, under Article 1, Section 8, they could refuse to fund the Army and Navy if the president did something like send American servicemen to Venezuela or somewhere that they didn't think that they should be. They have threatened that in the past. Presidents think that it's unconstitutional for them to dare call them on such things. Congress passed the War Powers Act in 1973. Presidents believe it's unconstitutional. This is when Congress said, well, if you send American servicemen abroad, you have to report back to us and tell us that you're doing that, and then we can decide whether to keep them there or not. Presidents believe it's unconstitutional. Congress believes it has the power, and we've never had a huge conflict, though, because Congress usually accedes to what the president wants and says, okay, you can go ahead and keep them there. So those are the powers of Congress. Things that federal government can't do are in Article 1, Section 9. Things that states can't do are in Article 1, Section 10. Then you have the executive branch. The powers of the executive branch are not listed in nearly the detail. That does say the president's commander-in-chief can ask for the opinions of the departments. Interestingly, the departments underneath the president And whether we have a Secretary of State or Secretary of Treasury or Attorney General, none of those are listed in the Constitution. The executive departments, the cabinet, are just things that Congress has passed laws setting up these departments. So I find that's one of the things people think are in the Constitution. And it's not. Whatever cabinet departments, 15 cabinet secretaries you have, or just what Congress says that you should have. The pardon power is listed. I've always thought about the pardon power. Most of the time, I think students kind of roll their eyes because it's not important, it's not interesting. Well, it's kind of important. There's nothing you can do about the pardon. It is a power complete in and of itself, and you can't undo it. If the president, is bribed and pardons lots of people, because of that, there's nothing you can do to undo those pardons. Treaty power, the appointment power. Presidents appoint a lot of important, not only cabinet ambassadors, cabinet members, federal judges, all federal judges, etc., giving the State of the Union, and the executive power, that the president makes sure the laws are faithfully executed, which is a huge, huge, huge power. And that is why the Department of Justice, as well as the FBI, the CIA, the ATF, all 50, all 94 U.S. attorneys, etc., are underneath the president in the Justice Department, which traditionally has been politically separated from the president and is not the arm of the president to do what the president wants. But that's more of a norm, and norms, every word, can be broken. The judiciary is in Article 3. One of the things a lot of people do not recognize is it just says the judicial power shall be a Supreme Court and such other courts as Congress may from time to time ordain and establish. And it says that you should hold your office during good behavior. It doesn't say how big each court will be. It doesn't say that you have to be of a certain age. To be a member of the House, you have to be 25. Senate, you have to be 30. President, you have to be 35. President, you have to be a native-born citizen. To be a member of the House, you have to be 7 years a citizen. To be a member of the U.S. Senate, you have to be 9 years a citizen. To be a U.S. Supreme Court justice, you have to be a citizen. You have to be a certain age. You have to be an attorney. No. I mean, technically, President could appoint a 2-year-old from New Zealand to the U.S. Supreme Court if the president wanted to, and the Senate confirmed that person. The president could do that. So Article 3 leaves a whole lot out there, that was filled in by Congress, the federal court system that we have today. So we have the U.S. District Court, which is the trial court, U.S. Court of Appeals, which is the intermediate appellate court, and the U.S. Supreme Court. These two lower courts, which are really, really, really important. Congress has, through various acts over time, especially the 1891 EVARTS Federal Judiciary Act, have established what lower federal courts will have. Article 4 deals with the relations between the states, so the full faith and credit clause, extradition, the amendments of states, the guarantee clause, which the Supreme Court has said means absolutely nothing. So under the Constitution, the federal government guarantees to every state a Republican form of government. And early on, 1849, Luther versus Borden, the Supreme Court said, we don't know what a Republican form of government is, and so if one side is saying the other side does not have a Republican form of government, that's a non-justiciable political question that we won't even get involved in. We won't worry about that. Amendment process is in Article 5. Amending the Constitution is really, really, really hard. Why? There are two ways to propose amendments. Either 2/3 of the House and the Senate propose an amendment to the Constitution, or 2/3 of state legislatures specifically ask Congress to have a new constitutional, to hold a new constitutional convention, a second constitutional convention. And then anything that comes out of Congress, 2/3 of the House and the Senate, or would come out of a constitutional convention that we've never had, would then have to be ratified by three-quarters of either state legislatures or conventions in 3/4 of the states. So you're talking about, of the 435 members of the U.S. House of Representatives, 290 of 435, 67 U.S. senators, as well as 38 state legislatures to agree to an amendment of the Constitution. So what's the only type of issue that you will get an amendment to the Constitution on? Something that the vast majority of American people agree on. Most of the time people will say, well, we need an amendment to do this, or we need an amendment to do that. We need an amendment to overturn a Supreme Court case. Those issues are really controversial. And anything that's really controversial, you won't get 2/3 of the House and 2/3 of the Senate and 3/4 of the state legislatures to adopt. And that is why we've only had 27 amendments to the U.S. Constitution. And not counting the first 10 amendments, which the Bill of Rights that came very quickly, over the past 225 years, we've only had 17 amendments. Less than one every 10 years. In fact, we had one 43-year period and one 61-year period without any amendments to the U.S. Constitution. Article 6 is a supremacy clause. Constitution, laws, federal treaties are the supreme law of the land, notwithstanding anything in state constitutions. And all federal and state officers have to swear an oath to support the Constitution. And finally, the Seventh Amendment just says the Constitution will be ratified upon the concurrence of 9 state conventions. Interestingly, it was a really close-run thing. We almost didn't get 9 states to agree, and had the 10th and 11th state, New York and Virginia, not agree. Probably the nation wouldn't have happened anyway, but it was. Now, one of the things the framers had to promise, though, to try to get ratification was extra protections for individual as well as states' rights. So Madison and Hamilton and others thought that they weren't needed at all. And then the anti-federalists, Richard Henry Lee and Patrick Henry and others thought that they were protections for states' rights and individual rights. You had all sorts of protections for individual rights in state constitutions. Madison and Hamilton said this new federal government is going to be really weak and you don't need protections for individual rights. But Patrick Henry said, well, yeah, you do. You do need that. So in order to get ratification in Virginia and New York, the framers had to promise the very first thing we'll do when we go to Congress is introduce protections for individual rights as well as states' rights against the federal government. And they sure enough did. They passed 12 of these. They sent to the states. 10 of the 12 were immediately ratified by 1791, and this is what we call the Bill of Rights. Now, from this history, these amendments are meant to suppress the power of the federal government. The first word of the First Amendment is Congress. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech, press, people peaceably to assemble and petition. Congress shall make no law. These days, all but 3 of the provisions in the Bill of Rights apply not only to the actions of Congress, but also the actions of states and localities too. So it's not just the federal government that will make sure that there's no established religion or prohibit the free exercise of religion or prohibit your freedom of speech or press. It's also the state of Georgia or Carroll County or Carrollton. They can't do that either. Now, how did we get there? Well, it was a really long process. It's called incorporation. And it was through the 14th Amendment. The 14th Amendment's due process clause. That 14th Amendment says, one of the things in the 14th Amendment is states can't take away your life, liberty, or property without due process of law. And so starting in 1925, in a case called Gitlow, the Supreme Court said, well, if states try to take away your freedom of speech or freedom of press in a certain way, that might be a violation of due process. And so we're going to say that the First Amendment, freedom of speech and press, are so important that states can't take away that without violating your 14th Amendment due process rights. And thereafter, other provisions of the Bill of Rights, especially during the Warren Court. One of the reasons why the Warren Court was so controversial with conservatives was that in case after case after case after case, the criminal rights provisions of the 4th, 5th, 6th, and 8th Amendments were incorporated and made applicable to the states in cases that you probably know of or have heard. Gideon, Mapp versus Ohio, Gideon versus Wainwright, Miranda versus Arizona. By 1970, all but 5 of the provisions of the Bill of Rights had been made applicable to the actions of states and localities. And in the last 15 years, 2 of the other 5 have been made applicable to the actions of states and localities, that being the Second Amendment in McDonald versus Chicago in 2010, and then excessive bail and fines in the 8th Amendment in Timms versus Indiana in 2019. Which means today only 3 provisions of the Bill of Rights do not apply to actions of states. That being grand jury indictment. States don't have to use grand juries, and in fact most states use something called information instead of grand jury indictment. 7th Amendment jury in civil cases. States constitutionally do not have to give you juries in civil cases, where in the federal courts they do, if you could have gotten a jury as of 1791. Plus the 3rd Amendment, quartering soldiers. Because we've never really had any cases because the government hasn't tried to quarter soldiers. So 3rd Amendment, one thing in the 5th Amendment, as well as the 7th Amendment are the only provisions not applicable to the actions of states. One of the questions I was asked was about the Establishment Clause. It comes from the First Amendment to the Constitution. It's very important that the separation of church and state. There's huge debate, has always been huge debate about what actually constitutes an establishment of a religion. The court, as it's gotten more conservative over the last 20, 30 years, have allowed more actions of the government to support religion, and that there are all sorts of interesting cases out there that happen all the time. I was also asked about the Second Amendment and what the Second Amendment actually meant at the time it was adopted. Generally, it was thought it was a militial right, an organizational right that, a well-regulated militia being necessary for the security of a free state, the right to bear arms shall not be infringed. It was thought, well, it deals with whether you have militias or not. It wasn't until, and there's cases of the Supreme Court, the Miller case in the 1930s, etc., said it's not an individual right. Until the court got more conservative, and in 2008, in the Heller case, the court suddenly said, no, it is an individual right. And then in 2010, they said not only is it an individual right, but also states, and we're going to incorporate it and say that states cannot deny you that right either. Let's see. So the Bill of Rights were in 1791. After that, we've only had 17 amendments since then. Some of them deal with elections, others deal with Reconstruction, what happened after the end of the Civil War, others deal with things happening in the progressive movement. So 11th Amendment came directly because of the U.S. Supreme Court case Chisholm versus Georgia, where the Supreme Court overturned that. And the first major case decided by the Supreme Court, and Congress then immediately passed an amendment to the Constitution that says, no, Supreme Court, we don't agree with you. And that's whether a citizen of one state could sue the state government of another. And the court, the Congress and then the states in the 11th Amendment said no, you can't. 12th Amendment dealt with how you elected presidents. Then we went 61 years without any amendments, and then after the end of the Civil War, 13th Amendment got rid of slavery. 14th Amendment gave various new rights to the new freedmen, including citizenship. All persons born or naturalized in the United States are citizens of the United States and the state where they reside. It was to get rid of Dred Scott, which was 11 years before. And then you have privileges and immunities, which the Slaughterhouse case said basically means nothing. The Due Process Clause, and then the Equal Protection Clause, which was very, very, very seldom used until the 1930s or 1940s. And now about half the cases decided by the Supreme Court are based upon the Equal Protection Clause. And that's how you got Brown versus Board of Education and all sorts of other, dealing with racial discrimination, gender discrimination, sexual discrimination, and other things through the 14th Amendment. 15th Amendment gave the right to vote to the freedmen, 1870. Then you went 43 years without any other amendments. And then you have 4 within a 7-year period because of the Progressive Era. So you have an income tax. The Supreme Court had said, under the Constitution, you cannot have direct taxes. And so the Supreme Court in the Pollock case said that an income tax is a direct tax and would be unconstitutional. So therefore you have an amendment to the Constitution. Therefore, every April 15th, you can thank or cuss the 16th Amendment. 17th Amendment, direct election of U.S. senators. If you hadn't had the 17th Amendment, the Georgia legislature would be electing, a U.S. senator for another 6-year term in 2026, as opposed to the people. 18th Amendment is prohibition. It's the only amendment that takes away the rights from people, as opposed to giving rights to people. And it was a complete failure. And that's why you got the 21st Amendment to repeal the 18th Amendment, and then women's suffrage in the 19th Amendment. Then, 20th just said the president shall be inaugurated on January 20th because Roosevelt had to wait an extra, 2 months before he could install the New Deal in 1933. So to get rid of the lame duck period, usually presidents were inaugurated on March 4th. And now it's January 20th. 18th was repealed in the 21st. 22nd is presidential term limits, 2 terms. I question greatly that some people think that someone can run again in 2028 because under the terms of the 22nd Amendment, you can only be elected president twice and only serve 2 years of another's term too. So the absolute maximum anyone could ever serve as president would be 10 years. Giving Washington, D.C. electoral votes was the 23rd Amendment. Getting rid of poll taxes, 24th Amendment. 25th Amendment has been in the news recently, some. 4 provisions of the 25th Amendment. First is that the vice president, when you lose a president, either through resignation or death, the vice president had always assumed the office. But it wasn't clear from the Constitution where the vice president actually assumed not only the powers and duties of office, but the actual name of office too. The first section of the 25th Amendment says you get the name too, so you actually become president. Then, Section 2 is how you get a new vice president. Because before 1965, if the president died, the vice president became president, but there's no way to get a new vice president. And so under how the succession worked, the Secretary of State was next, and then the President pro tem of the Senate, and then the Speaker of the House of Representatives, and then the Secretary of State, and Secretary of Treasury, Attorney General, etc. Congress just set out succession of who would be president once you lose the president and the vice president. But if you lose the vice president, there's no, then it goes directly to the Speaker of the House. Well, 25th Amendment said if you lose a vice president, or the vice president becomes president, you lose the president, the vice president becomes president, it's up to Congress to nominate, the president nominates who he wants as a vice president, and then if majorities of both the House and Senate ratify that person, confirm that person, he becomes new vice president. And almost immediately, within a decade, you had 2 new vice presidents that way. Gerald Ford, and then Nelson Rockefeller. You got as vice president through the 20th, and Ford later became president. The only person ever to serve as president who's not been elected either as president or vice president was Gerald Ford. Third part of the 25th Amendment is when the president knows he's going to be incapacitated. So let's say he's going to have surgery, he's going to be under anesthesia. If he sends a note to Congress, President pro tem of the Senate and Speaker of the House, that he is going to be not able to be president for a certain time, then the vice president assumes the powers and duties of the office until the president sends a note back and says, hey, no, I'm okay. So Reagan, when he was shot in 1981, sent a note saying, hey, I'm going under surgery, and so George Herbert Walker Bush will serve as president until I'm able to. And then hours later sends another note saying, hey, no, I'm fine now. I can exercise the office of president. The fourth, though, section is when the president is not able to do this, but the vice president and a majority of the cabinet or such other body as is said, that is specifically listed, and no body has specifically been instituted for this, say that the president is unable to discharge the powers and duties of the office. This is absolutely fascinating. So let's say the president has a stroke or is suffering from depression, and the vice president and the majority of the cabinet believe the president just is completely out of it mentally and cannot serve in office. They then will tell Congress, hey, even though the president thinks he's perfectly fine, or maybe he is, he's unconscious and doesn't know any better, the president's out of it. When they send this note, then the vice president assumes the powers and duties of office. If the president, though, thinks that he's perfectly fine, he can send another note and say, no, I'm perfectly fine. If he does, then if the vice president and a majority of the cabinet still think the president is not fine, it's up to Congress to decide the issue, whether or not the president is fine or not. So the fourth section of the 25th Amendment is really, really, really interesting. Luckily, we've never had it. You would have had it, say, if Louisiana had such, you would have had it in 1960 when Earl Long was put in a mental asylum, and then Earl Long said he was fine, and he had one doctor saying that he was not fine, and another doctor said he was fine, and his wife had put him in the mental asylum because he was having an affair with Belle Starr. But if you had that in Louisiana, you would have had Section 4 of the 25th Amendment. But you didn't have that in Louisiana at that time. 18-year voting is the 26th Amendment. Then the 27th Amendment. The 27th Amendment might be one of my favorite amendments. It just says Congress shall not give itself a pay raise until you have an intervening election. The reason why I think the 27th Amendment is absolutely fascinating. Remember I said that Congress, the very first Congress in 1789, sent the states 12 different amendments, 10 of which were almost immediately ratified. But of the 2 that were not ratified, one of them said Congress shall not give itself a pay raise without an intervening election. Now, it was ratified by 6 states. And Ohio in the 1870s, for instance, I don't know why, but nearly 100 years later, Ohio decided to ratify this amendment that everyone had forgotten about. And then in the late 80s, there was a student at the University of Texas that wrote a paper, as an undergraduate student, wrote a paper saying, well, what would actually happen if there was no time limit? Unlike most modern amendments like the ERA or others, there was no time limit specifically for amendments before, I think female suffrage maybe was the first one with a time limit, or prohibition was the first one with a time limit. There was no specific time limit, and so the question was, well, what if a number of states now ratify it, even though it was introduced and ratified by some states 200 years ago? Professor thought that, this is kind of a ridiculous question, and I think the guy got like a B+ on his paper or something. He was upset with that, so he decided to make it his mission to try to get this unratified amendment ratified. He started going to all these state legislatures, asking them to ratify it, and then you start having all sorts of scandals in Congress. So you have the House Post Office scandal, the House Bank scandal, and other things that Congress got in really, really great public disfavor, such that one public opinion poll showed that of like 65 or 70 different occupations, when the American public was asked, do people in this occupation, are they generally trustworthy or not, that less than a quarter of the people, less than 20% of people said that members of Congress were trustworthy. In fact, they were lower. They had a lower approval rating than used car salesmen. And so you began getting, starting in the late 80s, state after state after state after state ratifying this amendment. And finally, you had 3/4 of the states ratify it by 1992. And so the Archivist of the United States, who's in charge of saying what's in the Constitution or not, he's asked, is this now ratified? Is this part of the Constitution? And he said, there's no time limit. It just says 3/4 of the states. Doesn't say that it has to be 3/4 of the states within 7 years or anything like that. And now, yes, you do have 3/4 of the states to ratify this amendment. So yes, it is part of the Constitution. So it's introduced in Congress and passed by Congress in 1789, but not ratified by the states until 1992, 203 years later.
Okay.
And that's how we get the 27th Amendment. So that's, I think I've answered almost all the questions people have, but I'll be more than happy to answer whatever questions at all that you might have about the Constitution. Yes, sir.
You were talking about the 25th Amendment affecting a state that Huey Long, Louisiana.
That is if Louisiana had an amendment like that.
Okay.
Yeah, but no, it doesn't affect states at all. It's just the federal government, the president.
How does the due process clause apply to non-citizens?
Repeat the question.
How does the due process clause apply to non-citizens? Generally, if you look at cases, it depends upon the facts of each case. They have some process, but maybe not entirely the process that citizens would have. So it depends upon the situation. Yes, ma'am.
But the Bill of Rights applies to all people in the United States.
Yes.
Does restructuring the Supreme Court, would that require an amendment?
No. Under Article 3, it just says, you shall have a Supreme Court and such other courts as Congress shall ordain and establish. But it also says that judges of the Supreme Court shall hold their offices during good behavior, which is lifetime tenure. But it doesn't give a size of the Supreme Court. So the Supreme Court, Congress in the Federal Judiciary Act of 1789 sets out the size of the Supreme Court, and they set it at 6. And then the Federalists were losing power in 1801, and they decided to reduce it down to 5 to make sure that Jefferson doesn't get a chance to make a replacement of the first justice that will leave the court. But then Congress the next year, when the Jeffersonians are in control, keeps it at 6, so it never really goes down to 5. 1807 it goes to 7. 1837 it goes to 9. 1863 it goes to 10. So the lowest it's ever been is 6. The highest it's ever been is 10. Then in 1867 it goes down to 7. And then 1869 it goes to 9. It's been 9 ever since 1869. But Franklin Roosevelt in 1937 introduces his famous court packing plan, which said for every justice over 70 years old, up to the number 6, that the president, if they did not leave the court within 6 months, the president would get a chance to appoint an additional justice to the court. And so the court wouldn't. There were 6 justices over 70 years old on the court at this point, and it would have made the court go from 9 to 15. And then thereafter, how many septuagenarians you had on the court would determine whether the court would always be somewhere between 9 and 15. It might be 9, 10, 11, 12, 13, 14, or 15. Now, this is what Roosevelt proposed, had a good chance of passing Congress until a couple of things, especially the Supreme Court, which had been declaring huge chunks of the New Deal unconstitutional. In 2 cases in March of 1937, uphold both a major piece of New Deal legislation, the National Labor Relations Act, as well as a minimum wage law that the state of Washington had passed in West Coast Goodwill versus Pierce, because Justice Roberts switches from voting with the 4 very conservative justices, the so-called 4 horsemen, to now voting with the moderate liberals on the court. And that switch would signal that the court would not vote down progressive legislation by a 5-4 vote, caused Roosevelt's court packing plan, which is very, very, very controversial. For 2 months, it's all anyone could talk about. It caused it to die a quiet death in the Senate. So, but if Congress had wanted to, they could have passed it. and they could have raised the Supreme Court up to 15. So the one thing you can't do, so it's up to Congress how big the Supreme Court will be. The one thing you can't do is to get rid of lifetime tenure. So those on the Supreme Court, you can't kick Sam Alito or Clarence Thomas off the court now. But you could certainly make the court larger. I don't think you could do term. Yeah, some people want to say, well, let's have term limits. Let's have every president every 4 years gets a chance to appoint 2 people to the court or something like that, and they each serve 18-year terms. I don't see how you do that and kick people off the court because of lifetime tenure, serving during good behavior. But you could certainly enlarge the court if you wanted to. One thing to realize, though, is if one party comes into office and wants to do that, the next time the next party is in office, what will they likely do? Also, do that. I'm a little more in favor of it than I was 4 or 5 years ago, but I don't know exactly how you do that because of the way the Constitution is set up, Article 3 with lifetime tenure. But yeah, it's up to Congress to say how big the court will be. Yes, sir.
Where in the Constitution does it say that?
It's Article 3, the start of Article, the Supreme Court, the federal judiciary shall be made up of one Supreme Court and such other courts as Congress shall from time to time ordain and establish judges. Both of the Supreme and inferior courts shall hold their offices during good behavior and shall receive a compensation which shall not be diminished. That's the start of Article 3. That's where it is.
But that's saying that it's Congress that says how many justices?
No, so it doesn't have a number. But otherwise in the U.S. Constitution it says that, things that are not specifically mentioned in the Constitution, it's up to Congress to make those decisions. You can see this through the necessary and proper clause at the bottom of Article 1, Section 8, for instance. And so things like this are just up to Congress to decide. They're legislation to set the parameters of the court system.
But then if the justices don't like it, can they rule Congress unconstitutional?
Well, that's an interesting question. That if you do have, say, Congress passing something that they believe that they have the power to do, and the Supreme Court declares it unconstitutional, I guess the only power that Congress would then have would be to impeach and convict judges of the Supreme Court if they completely disagree with that. And we've had one justice impeached by Congress, Samuel Chase, who had one of the best nicknames of any Supreme Court justice or any American politician. He had he was an alcoholic, had a very red and runny face, streaky face, and he was called Old Bacon Face. So Samuel Old Bacon Face Chase was impeached. Jeffersonians hated him because he was an arch Federalist, and they impeached him in 1805, but the Senate did not convict him. He's the only Supreme. But from that comes this idea that you don't impeach and convict judges or justices for decisions that you disagree with. That's only for mis mal non pe. This is only for doing things that they shouldn't do, not in their decisions, but like tax evasion or bribery or things like that. We've had 10 lower federal court judges, Judge Porteous of the Eastern District of Louisiana being the last one in 2010 to be impeached and convicted, but it's all because they've broken the law generally. You don't have to break the law to be impeached and convicted, but it's because they've done things that most of the time have actually led them to be convicted of other things after they leave office.
Does Congress do the impeaching and the Senate the trial?
Right. So under Article 1 and Article 2, what happens is that To be impeached just means to bring charges against you.
Correct.
And it's just a majority vote in the House of Representatives.
Simple majority.
Right, simple majority. And then you have a trial in the Senate and you to kick someone out of office. And you need 2/3 of the senators to vote for conviction.
Who presides over the trial?
Well, that's an interesting question. Under the Constitution, if the president is impeached, the Chief Justice presides, and so that's why you saw Trump's 2 impeachments. You had John Roberts preside. Other than that, it doesn't say. And so other impeachment, the few impeachments we've had generally, it's just been the President Pro Tem, the Senate, who's been presiding in those impeachments. And an interesting case you had in the early 1990s was a federal judge that got impeached. And the trial was to be before the Senate. And the Senate didn't want to take the months it would take to listen to all the evidence. And so they basically said, well, the Judiciary Committee will hear all the evidence from the impeachment managers and from the defense attorneys, and then we'll come with a report to us, and we'll read the report, and we'll set time for debate, and then we'll vote whether to convict or not. And this judge, whose name was Nixon, is Nixon versus U.S., but has nothing to do with Richard Nixon. It's Walter Nixon, who was a judge in Mississippi, district court judge in Mississippi, who's been convicted of bribery, or accused of bribery at this point. He brings suit and says, no, you actually have to have a full trial in the Senate. And the Supreme Court said that, this is a political question that's best left up to the Senate. We're not going to touch it, and therefore we'll let the Senate do whatever they want to. Yes, ma'am.
Do you know why the authors believe the Supreme Court should have tenure for life?
I think generally it's so that they wouldn't feel the pressures of the day, the political day. That they're more protected, so they could actually decide cases like they truly believe they should be decided under the law, rather than following the political winds. Interestingly, a lot of states at this point had lifetime tenures for their judges, but as you got more into the Jacksonian era, most states got rid of it, such that most states these days, state Supreme Court, or it doesn't even, some state, New York, the highest court in New York is the New York Court of Appeals. So the highest court in whatever state, most of the time it's called state Supreme Court, but it doesn't have to be called the Supreme Court. Their judges serve 6 or 8 or 10 or 12 years terms. I don't think any state has a lifetime tenure for their state judges. Yes.
If I see the Supreme Court as all-powerful, let's say a president said these term limits for presidents that amendment is invalid. So it goes to the Supreme Court. The Supreme Court, it doesn't matter what the Constitution says. They say, yes, it's invalid. Then it's invalid. I mean, there's nothing you could do.
That's true. But there would be such a unless the majority of people are perfectly happy with that. Unless they want, the vast majority of people are very happy with this president, want the president to serve for life, But if enough people are upset with that, you would think that there would be enough political pressure that you would have impeachment proceedings or other things brought
Against the Supreme Court.
Yeah. But
Well,
yes, ma'am.
What amendment do you think should be added to our Constitution?
Repeat the question for us.
What amendment do I think should be added to the Constitution? I really haven't thought about that. To any rate, I know what amendments I don't think should be added. I mean, so. I know the one that came closest to being, ratified, but was not, was a equal rights amendment. the question being, but interestingly, while it was being debated, the Supreme Court started looking at gender cases much, much, much more narrowly. And so one of the interesting questions I've always had is if ERA were ever ratified, and now because you actually do have time limits for that, you probably have to go and you have to pass Congress and pass the states again to actually have it. And because the nation as a whole, these days, it would be harder to do than it was in the 1970s for that. But if it were ever passed, would the standard that would be set by, as it would be interpreted, would the standard set be different than the standard you already had with the Supreme Court? And I don't know the answer to that. So I don't know if it'd make a difference or not. Now, it might make a difference symbolically. We have protections for gender rights in the Constitution. But actual legally, would it make a difference? I don't know. Yes, sir.
Does the judicial branch, as the third branch of government, have any enforcement power over the executive branch? Specifically, I'm thinking Epstein files, that kind of thing.
Yeah. Well, the judicial branch, enforcement of judicial decisions is done through the U.S. Marshal Service generally, and the U.S. Marshal Service is part of the Department of Justice, which is underneath the president. So it's got Andrew Jackson famously said after Worcester versus Georgia that John Marshall's made his decision, now let him enforce it. And of course, there was no way to enforce it. Just like Roger Taney and Ex parte Merriman saying that it's up to Congress, but not the president, to suspend the writ of habeas corpus in Baltimore. And the Lincoln administration kind of laughed in his face and said, no, we're not going to release these people from Fort McHenry at all. So, in some ways, if the executive branch goes against the Supreme Court doesn't have.
Can I have your attention, please? The library will close in 30 minutes.
In the enforcement mechanism?
Selections and bring them to the circulation desk.
So it's hard to see, what the Supreme Court could do if the president went against a ruling.
Oh, yeah. I'm really fond of the preamble myself, and disappointed to hear that it has no power. I recognize that, but to me, it's how why we have government, and I think that should be involved in every Supreme Court decision and all that. So, how did it become something to ignore rather than something to use constantly?
Yeah, just what the court has said. Now that said, it has the ERA would have had. It has symbolic importance. If you ask someone what's in the Constitution, that's one of the things that they will know.
It's like a mission statement.
Right. Yeah.
Yeah, it does. Which I think would be important in making decisions.
Mm-hmm.
But
I think it's much more better than most academic mission statements. But yeah.
It says that not only no person shall be a senator or representative for the Congress or elector of president, vice president, or hold any office of the Lord military. If they have one of the things that says, because they have to swear to support the Constitution, and if they have engaged in insurrection or rebellion against the same, they can't. And it also says, or given aid or comfort to enemies thereof.
Right.
How are they?
Okay, so that's Section 3 of the 14th Amendment, I think, which there was, a case brought saying, I think it was Colorado did not want to said that we would not count electoral votes for Donald Trump in 2024 because of January 6th, because he had led an insurrection. And the case, not that Colorado would have voted Republican anyway, but the case goes to the Supreme Court, and the Supreme Court unanimously says, no, that just deals with former Confederates, and it doesn't apply to the present-day president. So you actually have a Roberts Court decision that Section 3 of the
How hard is it going to be to the term limits on the Supreme Court? Whatever.
I mean,
It's the next amendment.
right. So you'd have to have, for term limits for the Supreme Court, you'd have to have an amendment for that. Yes.
I know that there are two ways to remove the sitting president, impeachment or the 25th Amendment. So the legislative branch has a means of action. In essence, the executive branch has means of action. I guess you could say, well, the Supreme Court, the Supreme Court is going to hold the trial, so they have a little bit. Has there ever been a move towards finding a way for the general population, as some countries have, to call for the recall of a president?
No, I mean, I don't know of any major movement in the U.S. that has tried to do recalls. Some people have said you need recalls for federal officials. Now, some states have recalls for state officials, but I think it would be, with the Supreme, it would be impossible to have recall for federal officials constitution. That's so there was the term limits movement in the 1990s for members of Congress. So you have these qualifications in Article 1, Section 2 and Article 1, Section 3, that you have to be 25 or 30 to be a member of the House or the Senate. You have to be 7 years a citizen or 9 years citizen to be a member of the House or the Senate. You have to be an inhabitant of the state where you reside for the House and the Senate. And then a number of states, like Arkansas, tried to put term limits on members of Congress. And the Supreme Court in U.S. Term Limits versus Thornton in 1994 said that you can't add additional qualifications to Article 1, Section 2 or Article 1, Section 3. That is just those three that are listed, but term limits would go against that for federal officials, but you could have them for state. So just like you can have recall for state officials, but I think the Supreme Court likely would say the same thing for federal officials, that you can't have recall for federal officials, and especially for federal president, for the U.S. president. Now, if you had a constitutional amendment, but you can change anything if you had a constitutional amendment for that. I mean, I think it would be interesting to see an amendment setting a president just having one single 6-year term as opposed to 2. Traditionally, presidents can be elected twice. And if a president is reelected, maybe they're most powerful at the very start of their second term, but then they lose power very, very, very quickly, and then very quickly become lame ducks. To which I will be so fascinated to see if that follows the next year or two or not. So far, it hasn't really. But where do you find this breaking point when Republicans in Congress say, I want to be here after 2028. I want a long career in politics. And if the president's public approval number goes even further south, goes into the low 30s, I think there's going to be a point where Republicans will say, maybe we should start fighting back. But then you have Rick Wilson and others saying, well, what they're really afraid of is their physical health and safety. They're afraid that true hardcore MAGA people might come after them if they go against the president, which we've never seen anything like that at all.
And MAGA didn't like it either.
So
not anymore.
I don't know.
Because of that Second Amendment thing on the last number.
The Second Amendment didn't count for Mr. Preddy, though.
Right,
Yeah.
right.
Well, if it was up to you and you were suggesting ways that our country could protect itself from going through something like we're going through right now, which I think everybody would agree is awful. what can we do? I mean, other than requiring the president not be a convicted felon or something, what can we do to protect ourselves from it's happening again?
Yeah.
Education.
I mean, there.
Is it safe to put your public opinion on recorded?
No. I have tenure, but that just means it's a little bit harder to fire you, but not really.
I wasn't thinking of tenure.
Actually, it's time for us to go.
I think more so than anyone recognized, our system was built on a large collection of norms that we thought were there and would always be there. And we realized that if someone comes in and just starts breaking them, that there's no recourse towards that.
What could we have done ahead of time to control
I
something?
don't know, put some of those things in laws as opposed to just considering them norms. But I don't know, I've been thinking recently, this is kind of sad, I've been thinking, how do we all put it back in the bottle? And can we put it back in the bottle? And I don't know.
You're around a lot of young people who are studying the Constitution and politics and all of these kinds of things. Are you seeing the younger generation outlook on all of this? Is it different? Are they concerned? Or are you seeing any reactions from them?
Some. There's still a lot of apathy out there. Those who just don't care at all, or those who have kind of said, well, you know, it doesn't make a difference at all. So there's apathy, there's some unease, but generally I think, as we saw like the No Kings protest or whatever, it was older people who were out there protesting. You know, who've seen how society had worked in the past. And not the youth that were out there.
Do you think there's any fear on their part of it damaging their future careers or anything?
Freedoms.
Yeah, I think I don't see it. I don't really see it to any great extent.
Don't have it as much as we do.
I saw in a public opinion polling, just like 8 or 9 or 10 years ago. It could have been the end of the Obama administration or first Trump administration. It was a long time ago, before people talked about great authoritarianism in the United States, that it was like 25% of the world's population, people under 30 throughout the democracies in the world, thought that having a strong man or authoritarian would be good, would want that. And I think what we're seeing in America, I mean, a lot of it's because of one person and those around him, but I think it also plays into larger worldwide trends too. I mean, Nigel Farage could be, the next Prime Minister of Great Britain. So I don't know.
But then there's the Canadian. And there's the Canadian.
Yeah, there's more party, but
there's hope.
Thank you so much.